morning, and thank you for joining Thompson Hine's weekly Coffee Chat series. My name is Andy Davala. I'm a partner in Thompson Hine's Investment Management Practice Group. This is our 9th webinar in our weekly Coffee Chat series. These concise and practical discussions focus on a variety of developments that impact the financial service industries. Joining me today is my colleague Ed Redder, a partner in our Employee Benefits Group. Today, we'll explore the effects of the integration of ESG factors in ERISA plan investment decisions and other considerations that fiduciaries should keep in mind when making ESG-related investment decisions and exercising their shareholder rights. We will be discussing the final DO rules on investment selection and shareholder rights, possible changes by the current administration, and the potential impacts on ESG investing. If you have any questions or comments during today's program, we encourage you to join the discussion by using the Q&A box on your control panel. We will address your comments as we move through our discussion, and we'll try to leave some time at the end to answer these as well. We will follow up accordingly on any questions that we don't get to during our time together. With that, let's get started. So, Ed, let's talk about our title a little bit, R.I.P. ESG. That sounds pretty ominous. Can you tell me where that came from?
Yeah, thanks, Andy. And before I do that, I just want to say it's a pleasure to be with everybody on the call today and share our thoughts on this coffee chat. But yeah, Andy, so yeah, when you look at this R.I.P. ESG, it kind of is a head scratcher, right? But I think what's important to point out too is there's a question mark at the end of R.I.P. ESG, right? And so I phrase this as an open question, and really the genesis of this topic and issue and the reason for the title are two final rules that were adopted last year by the Department of Labor covering ERISA covered plans. One is a new rule on investment selection and the factors that can be used for selecting investments for an ERISA covered plan. And then the second is, and related to the first, is a rule on fiduciaries' exercise of shareholder rights in ERISA covered plans. And it's very clear, although the final regulations don't talk about this, certainly the preamble and the proposed regulations did talk extensively about ESG factors and the use of ESG factors and kind of the concerns that the department had over the proliferation of these types of investments and these types of considerations in retirement plans. And I think also acknowledging some confusion given the variety of sub-regulatory guidance that's been issued over the years in this area. And so that's kind of the genesis of our title, R.I.P. ESG question mark.
Thanks, Ed. Before we get into the details of those rules you spoke about, can you take a step back and kind of speak about what we mean by ESG in this context?
Yeah, absolutely, Andy, and thanks for the question. So ESG stands for environmental, social, and governance factors. Part of the problem that we have in defining this, and I think this was recognized by the Department of Labor in their preambles and discussion of the rules, is that there's really no single definition of what ESG factors are. When I think about ESG factors, one example that comes to mind is, let's say you have a company that is committed to using green energy, right, to produce all of its energy needs. And it decides, boy, we want to have a consistent message. So within our retirement plan that we sponsor and that we act as fiduciary for, we're going to select some funds, we're going to select some investments that follow the same kind of rationale and screen out companies that are fossil fuel companies or that generate or refine fossil fuels. And so that would be an example, at least, of an environmental, social, or governance factor that the Department of Labor clearly had its crosshairs on.
Yeah, and I'd also add that obviously it's something that's very prevalent in the investment management area as well. There are a lot of ESG funds coming out. The SEC has a recent initiative to have further discussions with both issuers as well as asset managers about what types of ESG disclosures should be made by issuers. And then on the flip side, for investment managers that want to run ESG products, that they actually have a bona fide ESG program in place, so they actually following a framework for ESG investing rather than kind of jumping on the bandwagon as it becomes a more popular offering in this space. So thanks, Ed. So these rules were issued by the DOL and apply to ERISA plans. Is that correct?
Yeah, Andy, that's exactly right. And just for the benefit of our listeners, just to step back for a minute and lay some groundwork. So ERISA is the Employee Retirement Income Security Act of 1974, and it governs private retirement plans, among other privately sponsored plans. There are certain exclusions, but generally speaking, it covers all private retirement plans, sponsored by private companies. And so I think there was a concern, by the Department of Labor about kind of this perceived proliferation of these ESG factors that made them want to step back and say, boy, are these factors really appropriate in a retirement plan setting, right? In a private retirement plan setting that's covered by ERISA. And so what are examples of the types of plans that are covered? Well, one common example is a 401k plan sponsored by a private employer, or a defined benefit pension plan sponsored by an employer, or a cash balance plan. So there are all sorts of types of plans that are covered, but generally they cover employer-sponsored retirement plans. And so these rules would certainly impact those plans.
Would ERISA also apply to IRAs then?
Yeah, this is actually, a tricky question that I've addressed many times with many clients. It depends. So generally not. Generally, ERISA is not going to apply to an individual retirement account unless it's part of an employer-sponsored retirement plan. And there are certain examples of those types of plans that utilize IRAs, and so there is a possibility that the IRAs could be covered by ERISA. Generally not, though. And so they are not subject to Title I, generally, of ERISA, which contains the Part 4, which governs the fiduciary obligations and prohibited transactions under ERISA. One caveat, though, and I want to make sure that this is clear, too, that doesn't mean that IRAs are not subject to prohibited transaction provisions, because Code Section 4975 actually contains separate, very similar but not identical prohibited transactions. And so those prohibited transaction provisions would still apply in the IRA setting, whether it's part of an employer-sponsored plan or not.
Great, thanks, Ed. Could you then briefly discuss what those fiduciary standards under ERISA would be for covered plans?
Yeah, certainly. So ERISA Section 404 has kind of the general fiduciary obligations for ERISA covered plans. And so there are several rules that we have to kind of abide by under Section 404. One is that fiduciaries have to discharge their obligations and duties solely for the benefit of participants and beneficiaries, and for the exclusive purpose of providing benefits to those participants and beneficiaries and defraying reasonable administrative expenses of the plan, right? So there's inherent in that the duty of loyalty, right? So we're acting for the exclusive benefit of those participants and beneficiaries. Second, there's a duty of prudence. So we have a high standard of care under ERISA, and so essentially like a prudent expert standard of care that applies to fiduciaries in the conduct of their fiduciary duties. Third, there's an obligation to diversify plan assets unless it's appropriate not to, or it's prudent not to. And then finally, we have to follow the plan documents, right? So every ERISA covered plan has to be governed by a written plan document. And so as as fiduciaries, we're charged with following the terms of the plan unless they're inconsistent with the provisions of ERISA. And so those are the 4 basic duties. And as I said, there are also certain absolutes, right, that the Department of Labor found to be problematic, and those are called the prohibited transactions. And so ERISA fiduciaries are also subject to, and other service providers are subject to the prohibited transaction provisions of ERISA and the code.
Thanks, Ed. That's very helpful background. With that, let's turn to the rules you previously mentioned. What are they exactly, and why did the DOL take action in moving forward with them?
Yeah. So again, as I mentioned earlier, we have 2 distinct rules that were finalized and became effective in the middle of January of this year. One is the final rule on financial factors in selecting plan investments. So as a fiduciary is exercising its duty to prudently select and monitor those investments within a plan, it has to meet its fiduciary obligations. And then the second is the exercise of shareholder rights, including proxy voting within retirement plans. And so interestingly, and we can talk a little bit more about this in more detail, but the 2 rules really don't, the 2 final rules really don't get into a discussion of ESG factors, though as I mentioned earlier, the preambles make it very clear that that was kind of the impetus for the 2 rules. There was this concern, again, by the Department of Labor of the proliferation of the utilization of ESG factors in selecting investments for plans, and also the exercise of shareholder rights. And so why is that a problem? So as I just mentioned, right, we have the exclusive benefit rule under ERISA, which kind of has within it the duty of loyalty. And so from the DOL's perspective, if a company says, listen, we want to help clean up the environment, right? We want to focus on clean energy, so we're going to select some funds that focus on that, and kind of disregarding the performance of those funds, or maybe the performance of those funds is inferior to other general funds that don't focus on ESG factors. That would be a breach of the duty of loyalty from the perspective of the Department of Labor. They would say, no, you've elevated these kind of these other factors, these extrinsic factors and goals above what should be the primary driving force behind selection of investments for participants and beneficiaries, and that's to enhance performance and reduce risk of those investments. So those were kind of the driving forces behind the governance. I would also say, and I think I mentioned this before, we did have this kind of confusing set of sub-regulatory guidance that's been issued over the last 30-odd years, where seemingly every time the administration changed, we got a different perspective on whether and to what extent ESG factors could play into the selection of investments. And so I think there was a lot of confusion in the marketplace on the role that ESG factors could play in selection of investments within ERISA plans. And so that's really what I think prompted the Department of Labor's pursuit of these 2 rules.
Great, thanks, Ed. So how did the DOL address these, perceived issues and potential abuses?
Yeah, and that's a great question, and it really gets into the structure of the rules. As I mentioned, there was a lot of discussion in the preamble about ESG factors and kind of the confusion over just what is an ESG factor. So instead of dealing with that, instead of trying to pin that down, kind of recognizing that they would not be able to, the DOL took a different approach. What they did is they focused on what they call pecuniary factors versus non-pecuniary factors. And so a pecuniary factor is one that a fiduciary prudently determines is expected to have a material impact on the risk or return of an investment over an appropriate time horizon, right? So is it material to the performance of the investment? And then if it's not, then it's a non-pecuniary factor. So again, they didn't say categorically that ESG factors were pecuniary or non-pecuniary. Clearly, though, that's their target. And in the preamble, I think this is important to point out about the structure and the discussion by the Department of Labor. They really felt like it's going to be a rare circumstance where an ESG factor is going to be pecuniary in nature. So again, the swinging pendulum, going from administration to administration, of being more relaxed and more liberal in the use of ESG factors to more conservative and really restricting the ESG factors, that has continued into these rules. And as we'll talk about a little bit later, it continues again with the change in administration, with President Biden taking office in January. So the structure of the final rule on financial factors really focuses on looking at pecuniary factors exclusively. So we need to focus on pecuniary factors. There's a narrow exception that was recognized by the Department of Labor, and that's if a plan fiduciary is unable to distinguish between two investments based solely on pecuniary factors. Then you could have kind of what's been termed a tiebreaker, right? So we can look at these extrinsic factors if everything else is roughly equal or pretty close to being equal. So it's going to be, first, you have to have the requirement that they have to be indistinguishable, right? That the fiduciary is unable to distinguish. Well, think about that from your practice. When do you have two investments that are indistinguishable based on pecuniary factors? There's almost always some difference in the risk or beta or alpha or the performance over 1, 3, 5, 10-year periods that you can kind of point at, right? So I think it's going to be a rare circumstance, and certainly the Department of Labor felt like and voiced that in their view it should be a rare circumstance. But again, they opened the door and allowed this to happen if it's a tiebreaker and you believe that you need to rely on a non-pecuniary factor, but you have to jump through some hoops, right? You have to document why the pecuniary factors were not sufficient alone. You have to say how the selected investment varies from the alternatives and how the non-pecuniary factors used are consistent with the participants' and beneficiaries' interests. So it's kind of a high standard if you're going to rely on ESG factors. But again, I think it's important to step back and say, okay, well, that's a tiebreaker if we make the determination that those ESG factors are non-pecuniary. It doesn't necessarily close the door on ESG factors from being pecuniary. So you could determine that an ESG factor in some circumstances could be pecuniary in nature, and that way you don't have to jump through this kind of analysis. But again, I think to wrap up on this rule, it's very clear that the Department of Labor thought that that these tiebreakers would occur very rarely and not be a common event in plans. And then similarly, we have the rule on the exercise of shareholder rights that also became final in the middle of January, and this really addresses, again, proxy voting for retirement plans. If you think about, a lot of retirement plans have mutual funds as their kind of slate of investments, or very often that's the primary kind of vehicle for investments within retirement plans, and so it's really proxy voting at the mutual fund level, not within the companies held by the mutual fund. So that's one item to think about. Also doesn't apply to pass-through voting rights that you pass through to the participants. So again, it's kind of a narrow, but kind of a narrow band of potential proxy voting that we're talking about, but it is real and it's there. And so when deciding whether to first exercise shareholder rights and then how to exercise shareholder rights, fiduciaries have to take into consideration a number of factors. One is, they always have to work for the economic benefit of, or economic interest of, the participants and beneficiaries. They have to consider costs involved. They can't subordinate the participants and beneficiaries' interests to their own or to some other third party, and they have to evaluate all the material facts that form the basis for their vote, and they have to keep records of their proxy voting. So it's very similar. Again, it's targeted at ESG factors. It's very clear, and so that's kind of a quick rundown, Andy, of the two rules and the structure. But I think, again, notably, the two rules really do not use the term ESG factors, but by design, that's what it's intended to address.
Mm-hmm. It seems that the term would may be an operative term when discussing the provision of these rules going forward. Has the DOL changed direction at all here?
Yeah, Andy, it has, and again, this is kind of what I related or called the kind of swinging pendulum. It has. So 2 weeks ago, exactly today, the Department of Labor issued a non-enforcement policy, and essentially, kind of in a one-page policy, said, "Listen, we've evaluated these. We've evaluated the rules based on." The president's executive orders for the promotion of the environment and public health. We've listened to third-party providers and other interested parties out in the community and in the marketplace, and based on that feedback, we don't think, or we're unsure that the rules kind of struck the correct balance on the use of ESG factors and non-pecuniary factors in making decisions on investments. And so as a result, pending further guidance from the Department of Labor has taken a position that it's not going to enforce either the investment factor rule or the rule on the exercise of shareholder rights, including, I should mention, some delayed requirements, including kind of basically the flat prohibition on a qualified default investment alternative using or having any reference to ESG factors or non-pecuniary factors in the determination of those investments. And so, again, we have the Department of Labor postponing or basically saying we're simply not enforcing these rules pending further guidance. Now, remember, that's just the Department of Labor taking that position. It doesn't bind third parties, right? So I suppose you could have a plaintiff that brings an action for breach of fiduciary duty based on a company's use of ESG factors in the selection of investments in their fund or utilizing those in the exercise of shareholder rights under the plan as well. It's probably the less likely party that would pursue a plan. I mean, certainly the Department of Labor is the primary concern for enforcement, but certainly that possibility is out there and is real.
Great. So in some sense, it seems that we've kind of come full circle on these issues. Do you think this is the last time we're going to hear about ESG investing and the DOL?
No, I don't think so. I mean, I think the genie's out of the bottle, right? I mean, I think there has been a proliferation of these types of investments and focus on these types of investments. So the Department of Labor is going to have to deal with it somehow. I think it's very clear that the Department of Labor under the current administration has a different view than the Department of Labor under the President Trump's administration. And so I think it's very likely, and in fact they are looking at it now, that we will have further guidance in both areas. Now, what that guidance will look like is up in the air, right? I think it could be kind of new guidance that follows the notice and comment structure. But I also think the way that the rule was structured, the investment factors rule and also the shareholder rule, the way that they were structured, not kind of targeting, at least explicitly, ESG factors, but using the terminology pecuniary and non-pecuniary factors, I think that actually opens up the door possibly to kind of tipping the scale a little bit through the issuance of sub-regulatory guidance, right? So for instance, the Department of Labor could issue sub-regulatory guidance kind of interpreting the term pecuniary factor, right? And they could say, well, no, we understand the preamble to the final rule kind of said that it's very rare that ESG factors would be pecuniary in nature, and you really have to truly consider whether they are or not, but could take a more liberal approach to what is considered a pecuniary factor, recognizing that there is this trend, and I think more and more investment advisors and investment managers do consider ESG factors to be pecuniary in nature and do have a material impact on the performance of investments. So I think that's one area where we could potentially see guidance maybe sooner rather than later. But again, I don't have a crystal ball. It's hard for me to predict what form that's going to take. But I certainly think those are certainly two possibilities for future guidance from the Department of Labor on this in this area.
Great, thanks, Ed. Again, if you have any questions or comments, please use the Q&A function. Otherwise, Ed's and I are finished with the materials we wanted to go through today for today's chat. Our next coffee chat will be hosted next Wednesday, March 31st. Our colleague Philip Sinning will be joined by Harry Nelson from Eventide Funds to discuss board considerations related to ESG. To register for this and other future coffee chat discussions, please visit the events page on the Thompson Hine website. To view our past coffee chat recordings, you can visit the Thompson Hine YouTube channel. Ed,
Andy, we do have a question.
We do have a question. The question is that how can a ERISA fiduciary demonstrate that ESG factors are indeed pecuniary?
And that's a great question, and I don't know that I've sorted that out in my mind completely. I would certainly urge plan fiduciaries. So typically, with an ERISA covered plan, very typically there is the plan sponsor, the company that sponsors the plan, and it also serves in the capacity as the plan fiduciary, right? It's the employer, and unless some other party is named, it's the plan fiduciary as well, plan administrator. But oftentimes, and I almost always recommend this, oftentimes plans where the employer will engage an independent investment advisor to advise them, right? Because most of the time, the folks who are at the employer are not experts on investing, right? They don't have the expertise, they don't have the training. And so under ERISA, if you don't have the requisite training, right, to follow and discharge your obligations under the prudent expert standard, you need to seek out third parties. And so most employers do. And so they retain investment advisors. So I would truly lean heavily on my investment advisor, who should be aware of the rules, should be aware of the issues raised, and pose it to them. We need to be able to demonstrate that this has a material impact on the performance and risk of an investment over an appropriate time period. And so I think it's really opening that dialogue and pressing your investment advisor on that issue.
Great. Thanks, Ed. Well, we thank you and appreciate your interest and for attending today's program. And again, thanks, Ed, for your sharing your insights today. When the webinar ends, you will be prompted to take a survey to provide your feedback. Your feedback is very important to us and helps us to continue to tailor these programs to your need. Thanks again. Enjoy the rest of the day and stay well. Thank you.
Thanks, everyone.